All right, so buckle up because we're about to take a deep dive into a legal battle that's playing out on a global scale. Think pharmaceuticals, patents, and a case that's going back and forth between the U.S. and India. It's a real legal thriller.
It really highlights the difficulties of international litigation, especially when you have patent laws that change from one country to the next.
Okay, so paint the picture for us.
Right, yeah.
What's actually happening in this case?
So we've got Pfizer, the pharmaceutical giant, along with some other companies going head-to-head against some Indian pharmaceutical companies. Zenara, which is now known as Hikma, and Cipla. And this is all happening in a Delaware court. It all comes down to an alleged patent infringement all over a heart medication called VYND Max.
VYND Max, that rings a bell. Wasn't that the drug at the center of a huge patent debate a while back?
Yeah, exactly. And that's actually a major part of this case. Pfizer, they hold the patent for VYND Max here in the U.S. But get this, their patent application was rejected in India.
So we've got this legal battle going on in the U.S., but the patent isn't even recognized in India. That's got to complicate things, right?
Absolutely. And here's where it gets even more interesting. Pfizer believes that there's a company in India, Softgel Healthcare, and they think Softgel has some key evidence that could really help their case in Delaware.
Wait a minute. Softgel Healthcare. If this is about a patent dispute between Pfizer and these other companies, where does Softgel fit in?
Ah, that's the twist. Softgel isn't actually being sued in this case. They're what's called a third party. But Pfizer's claiming that they have information related to the manufacturing and sale of the drug in India, specifically through their dealings with Zenara and Cipla.
So Pfizer's trying to get evidence from a company in another country, a company that isn't even part of the lawsuit, and their patent wasn't even recognized in that country. How does that even work?
That's where the legal stuff gets really fascinating. They're using what's called Letters Rogatory. Basically, it's a formal request from the U.S. court to the High Court of Judicature at Madras over in India. It's kind of like a way for a court in one country to ask a court in another country for help with getting evidence.
Letters Rogatory. It sounds like something you'd hear on a legal TV show. But wouldn't India just say, nope, not our problem? They have their own laws, don't they?
Exactly. And that's where international treaties come in. Specifically, something called the Hague Evidence Convention. Both the U.S. and India, they're both part of this treaty. It basically means they've agreed to cooperate with each other, on things like gathering evidence for legal cases in each other's countries.
So it's like a global legal agreement smoothing the way for evidence to be gathered across borders.
Exactly. It provides a framework for these kinds of requests and sets out the procedures that need to be followed.
But I bet Softgel wasn't too happy about having to hand over their information. What did they say?
They raised some very good points. The biggest one was, we're not part of the U.S. lawsuit, so why are we being dragged into this? They also said that having to disclose their confidential business information, things like their sensitive research and manufacturing processes, could really hurt their business.
That makes sense. No company wants to just give away their trade secrets, especially to a competitor. Anything else?
Oh, yeah. And this is where India's rejection of Pfizer's patent becomes a big deal. Softgel argued that because India doesn't recognize the patent, they shouldn't be forced to help Pfizer enforce it, even if it's indirectly, by providing this information.
Wow, they didn't hold back. So what did the Madras High Court say about all this? Did they side with Pfizer?
It's not that simple. They took a really balanced approach. They acknowledged the need for international legal cooperation, but they also emphasized how important it was to protect Softgel's interests. The court actually cited a really important case called the Norwich Pharmacal case. This case established that even third parties, those not accused of doing anything wrong, they can still be required to provide information if that information is relevant to the case.
So even though Softgel isn't directly involved in the patent dispute, they can still have to hand over evidence. Did the court address their concerns about Pfizer basically trying to enforce a patent that was already rejected?
Yes, they did. The Madras High Court pointed out that India had a reservation under the Hague Convention. This reservation was about something called pretrial discovery. This basically means that they wouldn't normally fulfill requests for documents if those documents weren't specifically named. But in this case, Pfizer was very clear about what documents they were looking for, and that made a difference.
So Softgel couldn't just use India's general reservation as a shield. They had to respond to those specific requests. But what about their concerns about confidentiality? How did the court deal with that?
To protect Softgel's confidential information, the court came up with something pretty interesting. They created what's called a Confidentiality Club.
A Confidentiality Club? I'd never heard of that. What is it? How does it work?
So imagine a really exclusive group, like a VIP club, but for legal documents. And they've got really strict rules about who can see what. Only a handful of people from both sides, like lawyers and experts, are allowed access, and they're all bound by these super tight confidentiality agreements.
So basically, the court's saying you have to share the evidence, but we'll make sure it's handled with extreme care. It's like treating it as top secret intel. Pretty smart way to balance things out, I guess. But let's zoom back in on Pfizer's strategy here for a second. What are they really trying to prove in Delaware, and what kind of information from Softgel could be a game changer for their case?
Remember those Indian pharmaceutical companies we talked about? Zanara, which is now Hikma, and Cipla. Well, they've both gone ahead and filed what are called abbreviated new drug applications, ANDAs for short, with the U.S. Food and Drug Administration. It's basically the process for getting approval to sell generic drugs in the U.S.
So they're basically saying, hey, we want to sell our own versions of VYND-Max.
Yeah,
And Pfizer's not happy about that, right?
exactly. Pfizer is arguing that by filing these ANDAs, Zanara and Cipla are basically saying they're going to infringe on their patent, the 441 patent, which covers VYND-Max. They're saying Zanara and Cipla are going to start selling generic versions before Pfizer's patent even expires.
I see. They're like, hold on a minute. You can't just jump in and start selling a knockoff version of our drug.
Hmm.
But how does getting evidence from Softgel help Pfizer prove that?
Pfizer thinks that Softgel might have some really important documents or information, stuff that reveals how those generic versions of the drug were developed. Because of their manufacturing and sales agreements with Zanara and Cipla in India, they could be looking for anything from formulation details to information about manufacturing processes, maybe even communications about their plans for launching the generics.
Okay, so they're hoping to connect the dots to prove that those generic versions are basically copies of VYND-Max and that those copies are violating their intellectual property rights.
Precisely. And this is where the whole evidence-gathering process that the Madras High Court ordered becomes really important.
Right. The court appointed a local commissioner, Mr. Adarsh Ramanujam, to oversee the whole thing. What exactly will he be doing?
He's been given a lot of power to make sure this is all done fairly and efficiently. He can call on Softgel employees to give testimony. He can demand they produce specific documents. He can even administer oaths. And remember, this is all happening under the watchful eye of that Confidentiality Club we talked about.
So they're taking this very seriously. They're not messing around. But even if Pfizer gets all of this information from Softgel, wouldn't they still face some tough challenges in Delaware? I mean, that whole thing about India rejecting their patent for VYND-Max, that could still hurt their case, right?
That's a good point. The U.S. court isn't bound by what the Indian Patent Office decided. They'll be looking at U.S. patent law and the evidence that's presented in their courtroom.
But couldn't the decision in India still have some kind of influence on the case in Delaware?
It's definitely possible. Put yourself in the shoes of the Delaware court for a minute. If they see that Softgel was really hesitant to hand over information, or if there were a lot of legal obstacles in India, it might make them wonder about how strong Pfizer's claims really are.
It's like this side story that adds another layer of complexity to the main plot. It might not directly determine the outcome, but it could sway the jury's opinion or affect how the judge sees the evidence.
Exactly. And that's where this case gets even bigger. We're not just talking about one company trying to get evidence from another. We're talking about different countries' patent laws, international treaties, and the fact that the pharmaceutical industry is becoming more and more globalized.
It sounds like we're about to witness a really important legal precedent being set here.
It definitely has the potential to change how we approach international patent litigation. As research and development for pharmaceuticals become more globalized, we can probably expect to see more cases like this, where companies have to try to gather evidence from all over the world, even if the patent in question isn't recognized everywhere.
This case could become like a roadmap for how to navigate these tricky legal situations in the future. But let's not jump ahead too far. I'm still curious about what happened after the Madras High Court made their decision. Did Softgel cooperate? Did Pfizer get the evidence they wanted?
That's the million-dollar question, right? And, well, that's where the information we have stops.
So we end on a cliffhanger. We know the stage is set, but we don't know how the play unfolded.
Exactly. Did Softgel actually follow the court order? Were there any more legal challenges? The sources we've looked at don't tell us what happened next.
So we're left in suspense. But something tells me this case is far from over. What are some possible outcomes? And what bigger implications could this have? I'm really interested to explore that next.
Okay, so let's pick up where we left off. We've been following this legal battle, with Pfizer trying to get key evidence from Softgel, this company in India, where their patent for VYN-Damex was rejected. It's the real international legal drama. We know the Madras High Court laid out the process, they appointed a local commissioner, and they even set up this Confidentiality Club to protect Softgel's sensitive information. But we're still waiting to find out what happened after all that. Did Pfizer actually get what they were after?
That's the big mystery. The court did their part, but the sources we have don't actually say what happened during that evidence collection process. So we're left to speculate, right?
Yeah.
On the one hand, maybe Softgel just went along with the court order, handed over the documents, let their employees testify, and that was it. But I have a feeling it could have been more complicated than that.
Oh, absolutely. There could have been delays, legal challenges, maybe negotiations about how much information they had to provide. Remember, Softgel really didn't want to get involved in this. They weren't just going to give in easily.
And even if they did eventually comply, the information they gave might not have been what Pfizer was hoping for. Maybe it wasn't clear, or maybe it even contradicted what Pfizer was claiming.
That's a really important point. What the evidence actually says is just as important as whether or not they got it. Pfizer's looking for that gotcha moment, something that definitively proves that Zenara and Cipla based their generic reasons of VYN-Damex on Pfizer's patented formula, but there's no guarantee they found anything like that.
So let's play this out. Let's say Pfizer got exactly what they wanted from Softgel. How would that change things in the Delaware case?
Well, if the evidence clearly shows that Zenara and Cipla were, let's say, a little too inspired by Pfizer's patented drug, it would make their case for infringement much stronger. Imagine they find documents that lay out how Zenara and Cipla developed their generics, and those documents directly mention VYN-Damex. Or maybe they find communications where Zenara and Cipla are talking about how to get around Pfizer's patent. That would be a huge problem for their defense.
Yeah, like they got caught red-handed. But what if the evidence from Softgel doesn't help Pfizer's case at all? Or what if it actually supports Zenara and Cipla's side of the story?
That would definitely change things. If the evidence shows that Zenara and Cipla developed their generics on their own, maybe using publicly available information or different methods, it would really weaken Pfizer's infringement claims. And don't forget, this is all happening in a U.S. court where the Indian patent rejection doesn't matter. Pfizer needs solid evidence to convince the judge and jury in Delaware.
It's like a high-stakes game of chess. Every move counts. But even if we set aside the outcome of this particular case, this whole situation has raised a lot of questions. Questions about international patent law and how companies can go about getting evidence from different countries.
You got it. This case is like a glimpse into the future of patent lawsuits in a globalized world. As the pharmaceutical industry continues to operate across borders, we're probably going to see more situations like this, where companies try to use things like Letters Rogatory to gather evidence, even when patents are being disputed in different places.
And this doesn't just apply to pharmaceuticals, right? This is relevant to any industry where intellectual property is important. Think technology, software, entertainment. The questions this case brings up have far-reaching consequences.
Absolutely. It's about finding that sweet spot, that balance. On one side, you have companies pouring tons of money into research and development. They want to protect what they've created and make back their investments through patents. But on the other side, we need to make sure people have access to affordable medications, and we need healthy competition in the market. And in the middle of all this, you have the courts. They're trying to make sense of these complicated legal issues, trying to uphold international agreements, and trying to make sure everyone involved is treated fairly.
It's like a giant, complicated puzzle,
Yeah.
and the pieces keep changing. So what's the big takeaway for our listeners? What should they be thinking about after hearing all of this?
I think the most important thing to remember is that we're entering a new phase of international patent law. The lines between different countries' legal systems are becoming blurry. This case shows just how challenging and complex that can be. It makes us ask ourselves some tough questions. Questions about how we protect intellectual property rights while also ensuring access for the public, and questions about how we can make sure things are fair and transparent in a legal system that's increasingly global.
It's a wake-up call. These legal battles are happening all around us, and they're shaping the industries we depend on, impacting our lives in ways we might not even realize.
And don't forget, knowledge is power. The more we understand about these things, the better prepared we are to have meaningful conversations and push for policies that find that right balance between encouraging innovation and making sure everyone has access to what they need.
Well put. This has been a fascinating deep dive into a case that's both complicated and incredibly important to the world we live in. I hope you've learned something new, but even more than that, I hope you're leaving with a sense of curiosity and a desire to learn even more about these issues.
The best learning experiences are the ones that leave you with more questions than answers. So keep asking those questions, keep exploring, and keep learning. Until next time.